Right. Now, in relation to this, sorry, Chair. In fact, I think what I'm going to do, let's move to the next issue, but so I'll come back to this in a different format, because what I intend to do, Chairperson, to try and save time is, once we've done an issue like this and gone through it as here, is then to juxtapose that with whatever the finding was in the judgment and then move on, so that we don't have to then retraverse the issue when we do the judgment itself here. But for now, can we just move so that was the finding, and then the next issue is at 5.2, which is page 40, regarding whether during his tenure as SARS Commissioner, Mr. Pravin Gordhan established an intelligence unit in violation of the South African intelligence prescripts, and if so, whether such conduct constitutes maladministration. So now we're getting to the so-called rogue unit issues, having disposed of the EMEA issue in the way that you've described. And this is what we called, in shorthand, Chairperson, the establishment issue, as opposed to the procurement or recruitment issue and so on. Yeah. Okay. So tell us, firstly, what were the parameters of this issue, the establishment issue? What was said, what you found, and what you took into account? And maybe in this one, fortunately, there were common cause issues, so you used your normal format here. Not necessarily word for word or blow by blow, but just take us through the highlights.
The highlights of this this issue had common cause issues. And you see the 5.2.1, we indicate that it was not in dispute that the allegations that the unit was unlawfully established, and that it has been in the public discourse. It was something which was discussed by various institutions, legal experts, so that is acknowledged. And but the issue of my determination was whether the institution or the unit was in violation of any legal prescripts.
Yes.
So
no, I think the part that you jumped might be the most important for the purposes of what's going to follow later. That you say that it was in the public domain. I think everyone who's a South African knows that. But you also refer to the reports.
Yes. And then when this matter was brought to the attention of SARS, because again, you see, we are investigating SARS. And when we investigate SARS, it's because Mr. Gordhan was the commissioner of SARS, the accounting officer. So we also then show that it's common cause what SARS has acknowledged in their responses, where they indicated that there was a unit and which was collecting information in respect of compliance with tax and custom laws. And this was confirmed by Mr. Pillay when he responded originally to the public protector when they were investigating the human resource related complaint of 2014. And the name of that particular unit, what was it called by then? Because you'll see in the report, we are even showing you step by step how the unit changed from one name to another name to another name to another name. But we will also show that the same individuals, the same modus operandi, the same equipment, which were the subject of our investigation.
Good.
Yes.
Yes, good. Hence we just call it the unit. So
yes,
without, because one, it was this, the CBU, the XYZ and what have you, but it, as you say, it was the same unit here. All right, now, then at 5.2.5, one of the criticisms when you get to the judgment is that you ignored or did not take into account the Nugent Commission.
Correct.
Yeah, well, then against that criticism, can you comment on what is contained in 5.2.5?
Yes, so this is the Commission of Inquiry into Tax Administration and Governance final report, which is the very same Nugent report. And we have captured the information that we receive a response from SARS. And SARS provided us this response where they were saying the Nugent Commission found that there was only a question why such a unit was considered to be unlawful. It's not clear. That's what the commissioner said. While a National Intelligence, a Strategic Intelligence Act prohibits the covert gathering of certain intelligence that applies to intelligence concerning threats to the safety of the state, which hardly applies to intelligence relevant to collecting tax, which indeed we agree to that members of the unit might at times have acted unlawfully. SARS employment policies might have been breached, that members might unlawfully have acquired and used equipment, all of which came later to be alleged. I see no reason why SARS was and is not entitled to establish such a unit to gather intelligence on the illicit trades, even covertly within limits. So that's within limits. It's very critical. And I must say, I agree with this. You will see later in the observations where I was very clear, because it's as if I'm now this person who doesn't want SARS to do their work, because their work is allowed for them to do that when they investigate information relating to tax evasion, illicit trade. Then he says, indeed, that was in view expressed to SARS in late 2015, which seems not to have been made public by SARS. An opinion was furnished to the former commissioner of SARS in 2015 in response to the findings of a panel chaired by Advocate Skakane, by Trengov SC, by Advocate Ngumalo, who advised SARS that it was said to be unlawful by a panel chaired by Skakane, but I find nothing in its report to persuade me why that was so. That's what he says. Advocate Skakane was asked if he could elaborate, by his reply took it no further than what was said in the report. Then he goes to the Judge Kroon, the Judge Kroon Advisory Board, which reported to the minister and issued a media statement saying the unit was unlawful. But the evidence, he told the commission, that was not a conclusion reached independently by the board, but had been adopted from the Skakane. So that's what the Nugent Commission was saying, which I will show now why it this week had to capture it and indicate that, yes, it was said. And we will show why it's differently to what we were doing as the public protector.
Okay. Yes, that's okay. That's exactly what I want to get into. Well, we'll leave for legal argument whether the statement by Judge Nugent, where he says something is not clear to him, means that it's unlawful, or rather it's lawful. So, but I want to get exactly to the point you're making now about whatever the terms of reference of that commission were. We don't know for now, but we know that they're not the same as your complaint, as it were. Now, here's the thing, because this Nugent Commission, when you are criticized, is trumpeted as, shall we say, an absolution of the unit. But if you go to paragraph 9, now wearing the hat of the public protector, not of Judge Nugent, can you overlook the things that he says? He says then that members of the unit might at times have acted unlawfully, that SARS employment policy might have been breached, that members might unlawfully have acquired the use of equipment, all of which came later to be alleged. Let's just take those 3 things. If he is now acknowledging, let's say, that those things might have happened, and for him, he brushes them aside. Now, for the purposes of your investigation, if you found those things, that employment policies were breached, members acquired equipment unlawfully, and so on, what finding would you have to come to?
You know, it's a concern because he never conducted an investigation.
Yeah.
Whereas possibly he was reading some of the affidavits and statements, which he was seeing that maybe that has been done. But from my side, I wouldn't just ignore such, especially being an investigator. A complaint is lodged. I'm there to make sure that any state functionary is compliant to the laws. Similar applies to, we'll still go to the judgment, which is criticizing me about this. The fact of the matter is, when the public protector investigate, and Wes being advocate, Judge Bakwa, who was the public protector, who knows our mandate clearly, when there's violation of any supply chain policies, when there's violation of the recruitment policies, and when there's violation of the law that this institution was established and it conducted its work contrary to what it was expected to do, I wouldn't definitely just brush it aside as the public protector because I'm an investigator. His terms of reference were dealing with broad issues of SARS. I was dealing specifically with the violations of these prescripts because of a complaint which has been lodged. So I wouldn't just ignore the information and brush it aside and say, because Judge Nugent has said these, and it's a commissioner and who was not investigating. And as public protector, we were investigating because we had to check what happened, what should have happened, whether the violation of the prescripts and whether there's any gap. And how can we remedy this? Because our intention as well, going forward, is to remedy and acknowledging that the public protector's remedial actions are binding. Going forward, the Commissioner of SARS, if these people who are surely interested in making sure that such things are not repeating themselves, they will learn from this, they will avoid doing this going forward.
Yes.
Surely. Yeah.
Okay, thank you. Then that then takes us, so I think it should then be clear that you engaged with the Nugent report at whatever level. You didn't ignore it. Yeah. Now,
Definitely.
The next issue then is the important issue of the Trevor Manuel memorandum that you referred to earlier. And again, Chairperson, to save time, I won't go to the actual, we've made references to it with Ms. Mkhwebane and so on. So we'll just use it as it is quoted in the report so that we'll just move along. Yeah. The references are the same as before. Right. Now, that memorandum plays a crucial role in your report. And I'd like you in particular to, what we know now in this committee about it is the fact that it was written to Minister Manuel. It was written by Mr. Gordhan, and he was requesting certain things. But I'd like you to just read 2.1, which I think is the important part of that letter or memorandum, and then comment on what it says to you.
This 2.1 says collecting tactical intelligence invariably means penetrating and intercepting organized criminal syndicates. This is an activity for which SARS does not presently have capability, including the legislative mandate to manage clandestine activity.
All right.
So this paragraph is very clear that SARS and under Commissioner Gordhan, they knew that they don't have the legislative mandate to deal with this or to establish such a unit with such capabilities.
Yes. And Chair, I'd like to highlight, because Ms. Mkhwebane testified that the key activities, and we'll deal with that when we deal with the operations of the unit. But the key things, which the red flags, were interception and surveillance. That was the evidence of Ms. Mkhwebane, and where she said those and it was also the using of a jamming device and so on. But those were just a few things that would, even for someone who's not familiar with the intelligence world, start giving you signals, as it were. Now, I want to zoom onto the first sentence. I see the point you make about the legislative mandate. That's fine. But it would seem that even at that early stage, there was an appreciation of the kinds of activities the unit performs. And so what do you read into that statement that says collecting tactical intelligence, which is what they were doing, invariably means penetrating and intercepting organized criminal syndicates?
This meant especially the interception of organized criminal syndicates, which they should be doing, especially if they violate tax-related matters and customs and illicit trade. But then it's very clear that the how part of it should be done by the institution which is allowed to be doing that.
Okay.
I think that's what it was meant to do.
All right. And then in case there's any doubt, the next sentence, 2.2, then says, discussions are taking place with the national intelligence to supplement SARS intelligence capability. The word supplement there, does it mean there was no intelligence activity at SARS?
This means there was intelligence, there was the SARS intelligence capability because they wanted to supplement it.
Yeah. All right. So let's then assume then that it will be considered by anyone that firstly, the interception activities taking place, or at least envisaged, and that there was some existing intelligence capability. And in any event, if this had nothing to do with intelligence, why would this memorandum be reached with NIA, not Department of Water Affairs and so on? Why else would it have been reached with NIA?
I think they acknowledged and they understood that it's not falling within their mandate. And they had to make sure that they approached the institution which is supposed to do that. And I think they had at the back of their mind section 209 of the Constitution.
Right. Because, thank you, because we know that, well, everyone knows that the institution in South Africa that does comply with section 209 of the Constitution, in other words, which conducts intelligence services and which is governed by national legislation, is NIA and Defense Force and the police, I think. But we know those institutions, correct?
Yes, in terms of section 209 is the defense intelligence, subs intelligence and state
National-
security.
Yes, good.